We will begin. We have one. I know there are a lot of people here on the Good Samaritan bill. We have one bill by Representative Lombardi, House Bill 7025, that only has one witness signed up. Both have promised me they'll be very brief. And with that, as they always are, and to the point, Representative Lombardi.
Thank you, Mr. Chairman, members of the committee. Mr. DeLauro is here with me. If I may ask him to join, Mr. Chairman?
Absolutely.
He promised me he would be short and sweet. If not, I have to hit him with an elbow. That's what he said. But we had this deferred sentence bill. You've heard it, I think, ad nauseum. Again, someone completes the terms of their deferred sentence. It's not a conviction. They pay the cost, they pay the fines, the assessments, they do make the restitution, they do the counseling, they do whatever is asked for in the court. There's a retroactivity in Section 3. It's a good bill. It especially affects those in the poorer neighborhoods, especially the minority communities, people where the education level isn't where it should be. So, Mr. Chair, members of the committee, I ask you please support this. Several people are looking forward to this, and it's really done at the direction of the court. The court has indicated that we have to make the necessary corrections. If there's any questions, I will endeavor to explain.
Thank you. Any questions for Representative Lombardi?
Thank you, Mr. Chair.
Thank you very much.
Chairman, I want to hold all bills for further study, please.
All right, Vice Chair Costa moves to hold the 4 remaining bills for further study. That's seconded by Representative Canario. All in favor?
Aye.
Is there any opposition? Okay, those 4 bills will be held for further study, at least for now. Thank you.
Any questions for me, Mr. Chair?
No questions. Thank you, Representative Lombardi. Mr. DeLauro.
Thank you. I can, in fact, keep this brief, although I have to summarize about 9 years worth of Supreme Court decisions, legislative action, but I'm going to try to do that. So in 2007, our Supreme Court gave a decision in a case called State versus Briggs and Mathias that made unclear what had been a really clear application of the law, at least since I started practicing in 1981. That is, at the end of a deferred sentence, if it is successfully completed, the case is dismissed. We litigated that issue before the Supreme Court. The Supreme Court said in a decision in 2007 that what you would need to do in order to fix this was to approach the General Assembly and have the relevant statutes amended. Then Attorney General Patrick Lynch, to his credit, introduced a piece of legislation in 2010. There's a copy of his testimony that's appended to the testimony that we submitted that says that since the Supreme Court, muddied up the waters on this, that criminal defendants were less apt to accept a deferred sentence. So the bill that the then Attorney General introduced was passed. It was enacted into law. Lo and behold, there was another challenge to it. This time, the Supreme Court, again in muddying the waters, said that, okay, now, number one, you didn't make it retroactive. In order to do that, you need clear and unequivocal language to that effect. The second thing, which is of more concern, is where they said, we are not going to address separation of powers issues at this time. So we went back to the drawing board. The retroactivity issue was easy. The case law is clear what you have to do to make a legislative enactment retroactive. That language is in here in Section 3. The separation of powers issues, to the extent that there is one, we avoid that completely. We believe we have avoided those completely by a more careful drafting of the applicable laws regarding deferred sentences and expungement. So that's kind of the lay of the land. The bottom line for this, to the extent that there is one, is this. This bill does not change any laws in Rhode Island regarding expungement or deferred sentences. It just makes it clearer and retroactive and constitutional. In other words, this is already on the books. and it just makes it's just a better draft. How did I do? I think that was about 3
Thank
minutes.
you. Thank you. It's a very important issue, and thank you, Representative Lombardi, for introducing it. I certainly didn't mean to minimize it by asking you to summarize your testimony. Mr. DeLauro has provided the committee with a very handy summary of everything he just testified to that sets it out very nicely. With that, Representative Almeida.
Thank you, Mr. Chairman. Mike, can you just help me with the separation of powers issue? How did that become an issue with this?
Well, because what's on the books now, the bill that the Attorney General asked be introduced, I think it was in 2010 and passed that year. It says it would be in the. It says basically at the end of the deferred sentence, the judgment is automatically quashed. The defendant is exonerated. It went further than it needed to go to accomplish what it wanted to accomplish. So any time this body says, well, I'll speak very plainly. Anytime this body says to the courts, you must do this, I think their hair goes up and they say, well, we're a complete and independent and co-equal branch of government, and you guys can't tell us what to do. You can make crimes. You can tell us what the maximum sentences are, but you can't tell us what to do with a particular case.
They as in judges you're talking about.
Yes. I think. I mean, I don't. Well.
All right, Mike. I'm good.
Thank you. Any other questions? Yes, Representative McEntee.
Hi. So I'm in support of this bill, but I'm looking at the language, and it says, provided that no person has been convicted of a crime of violence, generally speaking, and I am an attorney, how do you get a deferred sentence if you've got a prior criminal record?
That's a great question. So deferred sentences are the only sentence that I'm aware of in Rhode Island that the Attorney General has to sign onto it. There's actually a document that they have to sign. Mm-hmm. If the Attorney General doesn't sign the document, the judge cannot impose a deferred sentence. So it's been that way as long as I've been doing this work. So as a practical matter, any other sentence, the AG can recommend whatever they want, or the solicitor can recommend whatever they want, but it's up to the court to exercise their discretion and impose whatever they think is fair, more or less or something else. Deferreds are the only exception to that, and I believe in the expungement law, which this bill also amends, there is a prohibition against expunging crimes of violence. Mm-hmm. So that's why we think this makes sense to amend both laws rather than just the deferred sentence statute or the expungement statute.
So just one more question for clarification. So there would be no requirement of a motion to expunge in these cases? It would be automatic?
No, it is not automatic. And that kind of gets us back to the separation of powers issue to the extent that there even is one, is you're saying, you're putting it back to where it should be, which is, judge, this person is eligible, exercise your discretion.
But there'd be no waiting period, or would there?
Yeah, there is.
How long?
It would be at the end of the successfully completed deferred sentence.
But generally with felonies, you have to wait X amount of years before you can even motion to expunge, as well as with misdemeanors.
I think what this one does, though, Representative, is to say we're going to treat deferreds a little bit differently, as is the case under current law, and allow some relief upon successful completion. The idea with a deferred sentence is that there aren't all that many of them. Right. And there's a good reason for that. Because if you go, the way the law is, if you go 4 years, 11 months, and 28 days, and you get in trouble, the 5 years starts running all over again.
Right.
So we as defense lawyers got to be really careful and kind of, not put our clients in the jackpot. Right. Because it's a very attractive looking, possibility. But, not everybody's going to stay out of trouble that long, unfortunately.
And it's basically a felony filing.
Right.
And those crimes that you're talking about, those violent crimes, rape, they would never, the Attorney General would never agree to defer those sentences. It just wouldn't happen.
I agree, John. I've never seen it, so, yeah. Thank you.
Thanks. We do have a letter from the Commissioner from Human Rights, the Commission for Human Rights, also in favor of this legislation, which passed the House last year and the Senate committee, but didn't make it through at the end of the session.
That is absolutely correct.
So with that, we will conclude testimony on House Bill 7025. And